All right. Good afternoon, everyone. I hope you guys are doing well. My name is Saif Ali. I'm one of the associate attorneys at Monty Ramirez. I work as part of the business immigration practice. Joining me is attorney Maricela Alvarado. She's one of the partners in our business immigration practice. And today we're going to be talking about the presidential proclamation that affects H-1Bs. And we're also going to talk a little bit about the proposed changes that are coming to the DACA program. And we'll dive right in, I think, jump into what the requirements of the proclamation, the overview of the proclamation. I'm sure you guys have all heard of the proclamation by now. It's all over the news. It's all over social media. Um, the proclamation was issued September 19, 2025. That was a Friday, and it came in later in that day. And essentially what it did is that it put an effect date of September 21st, 2025 at 12 in the morning, essentially 12:01 in the morning, and to take effect for 12 months with the possibility of an extension. And essentially what it requires is a $100,000 fee for new H-1B petitions. And what are new H-1B petitions is kind of the vague area that wasn't really explored. The proclamation just dropped that information on us, and we didn't get any clarifying information from the government until that Saturday around 5 p.m. Central Time, where CBP and USCIS issued some clarifying guidance. But that's in a nutshell what the proclamation says, but we do want to talk about what does the proclamation actually require from employers. And essentially what it is that it's a $100,000 payment with each new petition that's filed after September 1st, 2025. The proof of payment, according to the proclamation, is supposed to be required at the consulate or the port of entry. So what that means is that the proclamation essentially directed the Department of State, which is what the government agency that governs consulates and embassies abroad, where you get your visa stamping, to refuse or to hold visa matters in which there's no proof of payment. Similarly, it also instructed CBP when admitting individuals to ensure that there was proof of payment to any affected petition. If there's no proof of that payment, then see if in the case of Department of State, for example, with the visa stamping, then the Department of State is instructed to hold on the visa issuance, and CBP instructed to deny admission if there's no proof of payment. Now, we'll talk a little bit about what exactly new petition means, who is affected. So when the proclamation came out and they talked about a new petition, they didn't really clarify, the government didn't really clarify what a new petition was supposed to be. And until we received some additional clarifying guidance on September 20th, which was that Saturday, as well as some of the reports from practitioners from the American Immigration Lawyers Association that came out throughout this past week, as to what kind of petitions are affected. What we know is that individuals who are, sorry, if we can go back to the last slide. If individuals who are filing the first time H-1B petitions on or after September 21st, 2025, who are outside the United States, which includes future lottery petitions, excuse me. So who does it not really affect? That would be any petitions filed before September 21st, 2025. So generally speaking, if you have an approval from September 20th or September 20th or September 19th or September 18th or any day before that, your petition is not affected, even if you go for a visa stamping at a later date. If you go for visa stampings, for example, we've had reports of and as have had clients and who have gone for visa stampings for petitions that were approved a month or 2 months ago, and they've been able to get their visas without any issues. For valid visa, H-1B visa holders, travel is still permitted. You're not going to be asked for a $100,000 fee when you're coming back into the United States. I think it was all over the news on that Saturday when the proclamation came out, that people were rushing to get off their planes because they were afraid they were going to have to pay the fee if they had to come back in. That is not the case. So if you have a valid H-1B visa, of course, given the travel climate that we're in, you should always be cautious when traveling, but you're not going to be expected to pay the $100,000 fee, or your employer is not going to be expected to pay that $100,000 fee when you return, as long as your visa remains valid. H-1B extensions Amendments and changes of employers for those in the United States also do not appear to be affected, although USCIS and CBP have not clearly stated as such. At this point, from practitioners from other agencies, as well as from American Immigration Lawyers Association, we understand that extensions, amendments, and change of employer petitions are being filed and receipted by USCIS normally. They're not requesting a $100,000 fee at this time from any of those petitions. We've seen receipt notices for petitions that have been filed since then come in. So we understand that right now, those categories of H-1B petitions are not being impacted. Additionally, although it's not quite clear at this time, reports from other practitioners from American Immigration Lawyers Association seems to indicate that changes of statuses for those people who are already in the United States do not seem to be impacted and are being received as normal. But right now, unfortunately, we have no clear or clarifying guidance from either CBP, from USCIS, or even Department of State as to whether these change of statuses are affected or not. Now, the proclamation also listed out certain exceptions. Right now, all we know is that the proclamation states that exceptions may be granted in the national interest, and they may be granted on different bases. So there may be granted on an individual basis. For example, if a beneficiary happens to be working on a project or or working in an occupation that serves the national interest, it may be possible to apply for an exception to the $100,000 fee on an individual basis. The proclamation also indicated that some companies or some corporations or organizations may be able to apply for a blanket waiver. For example, if the mission of that company or organization, or possibly even a nonprofit, is tied to the national interest, then there may be a company-wide blanket waiver available. And the proclamation actually even hinted at potential industry-wide blanket waivers, but unfortunately, we don't have any information on how to actually apply for those waivers at this point. The proclamation simply stated that there were going to be exceptions allowed in the national interest, or that there could be, but didn't provide any kind of guidance on how to actually apply for those, nor has there been any kind of guidance from CBP or from USCIS or from Department of State at which point does the national interest exception need to be applied. We do anticipate hopefully getting more clarity from USCIS on that matter, but as of right now, there's no information on how we apply for that blanket waiver. Now, right now, I understand that there's a lot of misinformation or lack of clarity, but we have some general best practice advice for all employers as well as beneficiaries. Please consult an immigration attorney. Reach out, discuss whether this proclamation impacts your case. If you're filing for example, your extension, I understand you may be worried. Hopefully, this briefing has kind of given you a little bit of an idea that you shouldn't be impacted. But if you're, for example, an F1 OPT student and you're thinking about your next year's lottery, or you're an employer who has F1 OPT students and you're thinking about the lottery for them for next year, please reach out to us, talk to us about how we can strategize in order to work on your future cases. And for right now, we do advise avoiding international travel, or before you file new H-1B petitions, which, as we discussed, we're talking about either new lottery petitions or new cap exempt petitions that are taking place after September 21st, 2025. Please feel free to reach out to us, discuss the case with us, so that way we can talk about the implications, whether this is one of those exempted categories or one of those categories that the proclamation doesn't apply to, or if the $100,000 fee does indeed apply in your case. We'll be able to provide you advice on that. But in the meantime, also please be sure, if you are engaging in international travel, H-1B, and any visa holders that are on this call, please make sure you check your I-94 every single time you come back in. Customs is making an unprecedented number of mistakes when they update your I-94 upon return. If you notice some kind of discrepancy, it may affect your status. So please be sure, if you see a discrepancy, reach out to us and talk to us about, hey, look, I noticed this problem. If it's something that can be corrected, then we'd be more than happy to guide you on how to correct it. Now, another thing that the proclamation did talk about, as well as it's been hinted in the media for some time, right now, I want to be clear, there's no official rule yet, but the Trump administration has been talking about a change to how the H-1B lottery system is conducted. Now, of course, the H-1B lottery for fiscal year 2026 has already taken place, took place in March. In next March, we anticipate that the fiscal year 2027 lottery is going to take place. Now, if this rule is codified between now and then, what it proposes to do is to weigh registrations for selection based on the beneficiary's wage level. So essentially, any petitions or any registrations that are submitted, and right now we don't exactly know how proof of wage level is going to be submitted, because at this point it's not part of the registration requirement. But at some point when we register for fiscal year 2027, the wage data will have to be submitted to the government, and the government is going to weigh those H-1B registration registrations based on wage level 4. And the way the system is going to work is that it's going to assign, or that it proposes to assign, for wage level 4 registrations, it's going to assign 4 slots in the lottery. For wage level 3, it's going to assign 3 slots in the lottery. For 2, 2, and then for 1, 1. So you can see how wage level 4s or higher paid compensated H-1B positions under this proposed rule. Again, remember, it's not a codified rule yet. It's undergoing the notice of proposed rulemaking. So there will be some time, and there will be notice if it does become a codified rule. But wage H-1B occupations that pay higher wages or pay higher salaries are going to receive preferential treatment if this rule takes place. Now, some frequently asked questions that we've been getting, again, things that we've seen come up over the last 2 weeks. Does this affect employees that are currently on STEM OPT? Yes. So as of right now, because number one, there don't appear to be any kind of, well, I'm getting ahead to the next question, but there don't appear to be any kind of exemptions for CAP exempt employers. But as of right now, STEM OPT employees who are going to be entering into the lottery, or even if they're working for CAP exempt employers and they're filing new H-1B petitions after September 21st, 2025, it appears that right now that $100,000 fee is going to apply to those new petitions. And so right now we do anticipate an impact, of course, between now and the lottery for fiscal year 2027, which is going to take place next March. Things can change, things will remain fluid. We'll have updates as they come out. So please be sure to stay tuned to our e-blasts. If you're not already getting them, please sign up for them. Any future webinars, which I'm sure we're going to have more in the future as this rules evolves. But as of right now, it appears that new petitions that for STEM OPT employees to be filed for the next year's lottery, or petitions that are being filed by CAP exempt employers after September 21st do appear to be impacted by the fee proclamation. Now, kind of got ahead of myself, but the next question, are nonprofit employers or CAP exempt employers exempt? No, so the proclamation didn't issue any kind of exemption for the fee specifically for CAP exempt employers or nonprofit employers. It may be possible for nonprofit or CAP exempt employers to apply for that national interest exemption, possibly on a company-wide basis, possibly even on an industry-wide basis. But as I said, unfortunately, the government has released no concrete information on how to actually apply for that exemption. But as that information comes out, we'll be sure to put out e-blasts and notices to clients and to the public on how to apply for and gain that exemption. And I'm sure that'll be a hot topic when the government actually does release some kind of concrete information on how to apply.
And I just want to add a little bit to what Safe said, just because there's a clarification on, and I saw the question come up. So the proclamation applies to, or does not apply to, for anyone that filed prior to September 21st, 2025, not obtained an approval by that date. So if you filed and it's still not yet approved, it's not subject to that proclamation, that $100,000. So that I just wanted to clear that up. So if you have a case that's been pending, it's still pending, but it was filed prior to that date, you should be okay. And then the other question, and I think I just wanted to touch back up on that first question about does it affect F1s that would be changing status? And I think one of where we all start questioning, because the proclamation says any petitions filed for anyone outside of the US. So we really are waiting for more guidance, but any new petitions potentially are impacted. Um, and so I think I saw a question just to kind of add that to kind of group it, is if we have an approval of a change of status, let's say that we can include or that change of status in the US is not going to be impacted, let's say in the next lottery, and then we want to apply for a visa leave. Again, we don't have guidance on that because I saw that question. Like if I get an H-1B change of status in the next lottery, and then I travel, will I be subject to that? We don't know. So that's why it's going to be important to not plan travel without talking to an attorney, because I know we have clients all the time that book their visa appointments before we even have an answer on the H-1B responses from the government. So it's best to kind of pause before you start, planning trips. And I know emergencies happen, but I did want to clear that up. Go ahead, continue, Save.
Right. And that's a great point that Maricela highlighted, is that right now we have a lot of either unclear information or sometimes even contradictory information from the government agencies. And so what we're reporting is what we do know, and what is unclear, we do want to make sure that you understand is unclear. And so that way you understand that you're informed about some of the risks about travel, about future petitions. And so you understand what's going on. And hopefully as new guidance comes out, as new clarity comes out, we'll be able to answer some of these more questions with a firm answer instead of saying, unfortunately, we don't have any guidance. But right now, that really happens to be the case, is for many of these questions, is that unfortunately, we don't have any clear guidance. And I think, Marisa, I think you touched on this fourth question, which is, does the fee apply when traveling abroad for visa stamping? So if you have a petition, again, that was received before September 21st, that 12:01 a.m. deadline, then if you're approved after, you should be able to go ahead and get your visa stamping. The fee should not apply in that case. For older petitions that were received before that deadline, I can say that we have had successful visa stampings take place since then. And so the Department of State does appear to be granting these visas, these new visa stampings, without requesting the $100,000 fee, again, for any petitions that were filed before that deadline. Now, if unfortunately with travel, there's always additional risks. Right now at the consulates, at the embassies, they are taking care to do extreme vetting, and so all travel right now is risky, but the fee should not apply when traveling abroad for visa stamping for any petitions submitted before that deadline. If you have travel plans, or you're thinking to travel and you had a H-1B petition that was submitted or received by USCIS after that September 21st deadline, please reach out to an attorney before making travel plans. And that final question, how do we pay the fee? Well, you would think that the government would make that obvious, but turns out they actually haven't. We have no idea, no guidance from the government on how to actually pay the fee. The proclamation seems to indicate that the fee needs to be made out to DHS, but DHS, which is Homeland Security, USCIS, CBP, have not made or issued any kind of guidance on how the fee is supposed to be paid to those agencies, or whether it needs to be paid to Department of State. Unfortunately, there's just no clarity on that point right now.
And then go ahead. You can go ahead and talk about this. Just this is a quick, or I'll take over. So this is just on the new proposal. We wanted to just kind of give this update. We are gonna have a future webinar on this, so we're going to invite many, because I know we have employees and employers here, so this is relevant a lot for employers, about the new government proposal. For relating to DACA recipients, now USCIS has indicated that there's going to be a proposal where they're going to continue adjudicating those initial DACA applications have been pending since the injunction, or before the injunction. And so, but the other part is that in Texas, these individuals may lose work authorization, or will not qualify for work authorization, specifically in Texas. So as of right now, we're not telling people, oh, move to Texas, because we don't really know if there's going to be any intervention, or that proposal might not come through. So we do ask that, we are careful with what we are putting out there, and of course, giving advice on this. Is it a risk that DACA recipients could lose work authorization? Yes. But they could regain it in another state. Of course, if their DACA recipients are moving to Texas, although they live in a state that it isn't going to lose it, then again, it's going to be based on state of residence. So if they move here, they would lose work authorization. But again, we're going to make an announcement for our upcoming webinar related to this DACA proposal, and hopefully we'll have clearer answers at the end of this month. But we're going to open up. I know we've already answered some of the questions in the Q&A, but we'd like to open it up to if anybody wants to speak on it, or just enter another question in the chat, as we have 10 minutes.
Yeah, I do see some questions, or at least some of the answered questions about annual fees for if you already have an H-1B, or for extensions or anything. Again, if anything was filed before September 21st, 2025, the fee does not apply. It doesn't appear that the government is retroactively going after employers for anything that was filed before then, or anything. Let's say, for example, you filed something, 2 weeks before September 21st, and it got approved, yesterday. It doesn't appear that USCIS is applying that fee to anybody. Again, it seems to be based on the receipt date of the petition by USCIS, as long as it came in before that September 21st deadline. And then as far as extensions, if you already have an H-1B employee and you're filing an extension petition for them, or you're filing a amendment petition for them, let's say something about the job has maybe changed, the fee will not apply in that case.
Okay, so we have a question here. We'll read it out loud. Does the government shutdown have an impact on visa stamping outside of the country? Right now, what we do know, USCIS is one of the agencies that doesn't get impacted. As far as Department of State, they are still operating for the most part. I do think that there's going to be slowdowns. We've been having communications with the consular officers, and they're responding. So I hope that means that appointments are being kept. But there are going to be slowdowns. So as far as H-1B and PERM cases, the Department of Labor is impacted. So we'll be dealing with that. Another question we have is, can you provide more information on the extreme vetting that H-1B beneficiaries could potentially experience at a visa stamping appointment? Sid, do you want to take that one? Or
Sure. So right now, the extreme vetting means that the Department of, you may know this if you filed a DS-160 anytime recently, is that you give away your social media information, your email addresses, to the Department of State. Right now, given the environment that we're in, Department of State is really conducting thorough checking of all of your information. Sometimes I know in the H-1B context, beneficiaries assume that going for a visa stamping is kind of just a rubber stamp. The H-1B petition is already approved, and it's true that the H-1B petition approval does, indicate that USCIS has approved your case. But the Department of State has a different job when you go for your visa stamping, and their job is to make sure that, yes, USCIS did approve you, but do you actually qualify? Are you admissible from the United States, or or is there any kind of flaw or defect in your application or in your previous actions or anything that you've done previously that would render you inadmissible to the United States? And that's what they're really honing down on right now. They're going to be checking in to make sure that your social media, your previous applications, any DS-160s you filed previously, if there happen to be inconsistencies, that might be something that gets questioned at the embassy. So in general, right now, the consular officers are really drilling down into your past applications. And so I would always caution beneficiaries, please don't think that if you're going for a visa stamping, it's just just another regular day, and they're going to look at your petition and just stamp and approve. We hope that's what they do, but given the proclamations to the Department of State, the extreme vetting requirements, they're going to be drilling into your past and into your background.
Thank you. All right. So our other question we have here is, does the 100K, is it 100K per petition applied to each person, or if the petition is for multiple persons, when persons, then only fee for all those under the, okay. So I think the question is it per person? Is it for multiple people? So it is per petition. So, and just a reminder that H-1B rules are very, very strict on who pays their fees. So Obviously, the fee would be an employer fee, so paid by the employer, but it is per petition. And the next question, will this new change affect remote workers? And I'm assuming we're talking about DACA, or I'm not sure if that means H-1B, because for H-1B, it's per petition, doesn't matter whether you're a remote worker or not. If you're talking about in the DACA context, so if you are, let's say, working for an employer not in Texas, but you live in Texas, do you still have work authorization in that state? No, because it's based off state of residency. So if you are a remote worker in Texas, working for an employer in California, I mean, and this rule does take, these changes do come through. I would advise, move to California where you can keep your work authorization. So if you live in California but have an employer in Texas, that situation wouldn't be impacted.
Great. And then we have another question. Would you advise employers to communicate caution in overall international travel, whether impacted or not by the proclamation, whether on H-1B or F-1? Yes, I think right now, in general, travel is kind of a risky proposition. We understand that some travel is business essential. So of course, if there's if questions related to travel you have, please feel free to reach out. We'd be more than happy to guide you. But yes, right now, travel, not just if you're going for visa stamping, you may think, oh, I'm not going for a visa stamping. I have my visa already and I'm just going and I'll be coming back in. The extreme vetting applies not only to Department of State, but also to Customs and Border Protection. So when you transit in and out of any kind of port of entry, whether it's the airport, whether you're traveling by the land border, right now, Customs is making sure we've had reports of people being pulled into the little rooms and the officers going through phones, checking social media, checking, photos, checking work emails. You may have heard of the case of the Norwegian man who there was a meme of President J.D. Vance or Vice President J.D. Vance in his phone and whose visa was revoked. So right now we are in an environment of extreme vetting. We do urge that, making sure that your employees are, if they must travel, that they're equipped with the information that they need, that they have their approvals, their visas, pay stubs, anything that will help ease their or be required for their reentry into the United States. It's important to prep for that before any travel happens.
All right. Thank you, Said. All right, I'll answer this one. So it's related to DACA. If there is an employee who is renewing their DACA status in California in October, but the employee is moving to the corporate office in Texas, what would be the implication of this for the employer? So this is where it does become a problem. DACA recipients or and this is talking H-1B, I'm talking everyone here that is on any kind of visa status or some kind of immigration benefit. There's a requirement to update your address anytime you move within 10 days. So if she's maintaining her residence California and is just coming in for maybe site visits or for meetings, her residence stays California, she keeps her work authorization. But if that employee moves to Texas because of this transfer, they have to update their address with USCIS. And the moment that they see that change of residence, there would be potentially a revocation of their employment authorization and they would lose it. So they are planning on, if this proposal goes through, they're going to revoke. So employers will probably receive the notification in their e-verify systems, possibly that there is a revocation. So I think in that scenario, it might be wise to pause or think about other considerations, maybe waiting, because I believe this proposal, we're supposed to have more of an answer by October 27th. All right.
The next question is, I'm on OPT. Is there any impact on applying for STEM OPT? And can I travel with STEM OPT status? The proclamation itself doesn't impact you going from OPT as an F1, going from OPT to STEM OPT. That procedure remains as it is. You should make sure you follow all DHS and ICE's SEVIS guidelines when you're transferring. Make sure you apply for your EAD on time. Right now, like I said, while travel is risky, travel with STEM OPT is still permitted as long as you gather all the necessary documentation. You get your I-20 that's endorsed for travel from your DSO. It's still permitted. And again, if you have an F1 visa, you're not going to be the $100,000 fee. It doesn't impact you if you're coming back in on that F1 visa. What we're talking about is really it's a localized impact to H-1B specifically.
All right.
The next question is, will the proclamation affect students that employers register in the lottery next year that are already in the US? So that's a great question. You're touching on one of those nuances that is in the lack of clarity that the government has given out so far. The proclamation talks about new petitions for people who are outside the United States, but the administration has also released some unclear statements, not official guidance, just unclear statements about application to next year's lottery. We think that the intent is to apply it to next year's lottery registrants, the fee, but there's no, like I said, there's no clarifying guidance specifically. The tension here is that the proclamation says one thing. It says new petitions for people outside the US, and then the clarifying guidance right now that has come out says new petitions and then exempts, extensions and all of those things. But right now, we don't have clear guidance whether students who are here right now in the United States that will be registered in the lottery for next year in next March, whether the proclamation is going to affect them. I think that it is the intent of the government for it to impact them, but there's a lack of clarity between what the proclamation says and the guidance that's come out so far.
Right. And then I think the other question I'm still not understanding is this. The question is met if they have an LC in Texas, but my workers living out of the country. So it sounds like they don't live here, so they don't have status. So this proclamation doesn't impact them at all. And then I think next question is, can you dive more in depth in the change of status aside from L1 to H? And again, I think the answer remains the same. It doesn't matter what status they're changing from. We still don't know how that implication, well, whether change of status, not whether. I mean, F1 is the example because it's the more common one, but I think it's going to be relevant with any status that they're potentially trying to change status from. And I believe one of the guidances that was given out even from the Department of State regarding the proclamation is about people trying to use other visa types in order to enter the country. So B1, B1, B2, trying to enter the US on a B1 to do a change of status. So again, we're hoping to have more guidance on that. But I think right now we have to think about it in terms of whether it's any status. I think they're going to be treated similarly as far as the proclamation goes. All right.
It looks like that's all of our questions. Thank you everyone for joining us. We hope this answers some of the questions. I know that there's a lot, like I said, one of the words we've been using a lot is lack of clarity or unclear. And I know that right now the government guidance is not really clarified what this is, but we hope that this has given you a little bit more information about the situations where the fee does not apply to and the situations where it may apply to in the future or is already applying right now. And of course, if you have specific guidance, please feel free to reach out to us. Our contact information is on your screen. We'd be happy to consult with you on your specific case or your company's case and give you more guidance as needed. So and we'll have more information. We'll be doing webinars, I'm certain, in the future as information comes out. I think we're going to be addressing DACA at some point if and when that rule becomes final. So please stay tuned and sign up for our e-blasts and so that way you can get the latest information as it comes out.
Thank you.
Thank you, everyone.